And good morning and good afternoon to those of you who are joining us today. Can I just say I'm delighted to be addressing you all from wonderful Hong Kong. And I should say a little bit about myself. I was responsible for setting up the new trade department in the UK once a decision was made in the UK to leave the EU, and spent a couple of years doing that before coming out to Hong Kong to sort of further our trading relationship with UK, Hong Kong, and of course through Hong Kong into China, and also to promote the investment offer of the UK back. Um, so that was about 3 years ago, and the first 18 months were a breeze, um, and there was a lot of healthy collaboration going on, healthy trade flows, healthy investment flows, and I would say a pretty solid political relationship was in place. Um, I'm not going to go through a blow by blow of everything that's happened since, but a combination of um, Brexit and trade negotiations between the EU and the UK, combined with political challenges and protests on the ground in Hong Kong, and now across the entire globe, COVID. I mean, the kind of situation has gone a bit sort of crazy, and interestingly, you know, during all of this, and a lot of things have been said in the press, the media, lots of reporting of uh, different perspectives on some of these events. Um, but when I go back to following the money and following the decisions that traders and investors are making, I still am surprised but delighted to see that there are very strong trade flows continuing. In fact, in the last year between the UK and Hong Kong, trade went up 16%. Our trade with Hong Kong and through Hong Kong into China is now at a record high of over 100 billion, and that's sterling. And the investment flows, unsurprisingly, for some of the more sort of uh, long-term investors, they see opportunity, particularly when there's these uncertainties, if they can get assets for the right price, or if they see a long-term value in the underlying value of what they're interested in. And to give you a sense of some of the sort of key developments, over recent times, you've got around $750 billion invested into the UK in around 16,000 projects alone, creating about 600 jobs in the last sort of decade. Around 4.5 million people employed in the UK depend on that foreign investment. So it's the foreign investment that's driving the employment. I'm delighted that the UK remains a number one destination for foreign direct investment in Europe. We're second in the world for study, 485,000 international students pursuing degrees in the UK in latest figures in 2019. We're fourth on the brain gain sort of index, which is, still a sign of, is this a good place if you're trying to attract talent? We do remain the fifth largest economy, eighth for ease of doing business, and still the lowest corporation tax in the G20 at 19%. Now, this week alone, the Prime Minister in the UK has been making various statements. And before I sort of tell you a little bit about what he's had to say on the future for the UK, I should mention the two big existential challenges that the UK are facing, which number one is the trade deal with the EU, and the second is COVID. And I can tell you from firsthand knowledge from engagement I've had with Number 10 and with government ministers over the last year in particular, they are desperately keen to get back to the agenda that got them elected about a year ago. But they know that they will not be able to do so until they overcome these two big challenges. Brexit, you will have read a huge amount if you follow it in the press over recent years. The thing that I observe, and I have no direct inside knowledge to how this will play out, although I do hasten to add I am an optimist, but Brexit is going to get concluded soon. So, you know, one way or the other, it will get concluded soon. In fact, I've just been on a different call with lawyers in London, commercial lawyers, who believe from where they're sitting a degree of optimism, and they report from the conversations that they've been engaged in that the negotiations are now in what's called the tunnel, and the tunnel should, if it's approached in the right way, lead to a deal that can be done. But I think we don't have to wait long for certainty on what Brexit means for the UK. I think on COVID, again, you know, it's an absolute tragedy globally, the impact it's had on lives, on people, etc. The UK has, you know, it's getting a running commentary on every step it takes. If I contrast the handling in Hong Kong to the handling in the UK, it must be, you know, quite challenging for people to look at the UK's handling and think we've done the best job. The focus, though, has all the while through COVID has been to develop both reliable testing and reliable vaccines. Myself and the panelists were talking about the Singapore-Hong Kong bubble that is about to open up in a week's time. The science behind that bubble was developed in Oxford University. The global financial markets had a bit of a bounce this week on the back of vaccine news, which again was a partnership involving AstraZeneca. So, you know, at the end of the day, until we vaccinate people and we find a way of regularly testing people, then COVID will become a problem. So just to sort of at least share that, you know, we feel a degree of light at the end of both of those tunnels, and that's what the UK has been focused on. I mean, where the Prime Minister has been on this is basically to get the message out there that the UK is very open to foreign investment. There's a reason why we were number one in Europe, and there's a reason why there's been so many projects come to the UK. It's because there's a very open attitude to foreign investors coming in. He announced on Monday that a new office for investment would be created inside number 10, and that's pretty much for the big investors who find it, want an easier ride in how they get through the various rules that one has to overcome, particularly if you're doing major investments like gigafactories and all these kind of things, which take planning rules and what have you. The other thing that has been announced this week is that we will equally, and some of this learning comes from, frankly, COVID, we'll be looking at the things that matter to the UK in terms of its supply chains, making sure that we're not overexposed in terms of dependency for certain goods and products to the degree that when you end up in a situation of some crisis like COVID, that you're not able to support yourself. One of the things that we learned is that 60% of the world's paracetamol is produced in India. So when the Indian government announced that they were closing all exports at the start of COVID, the world panicked a bit. Now they loosened off on that. But you don't want to be in those situations again, and some legislation has been sort of published to try and put in place a bit of understanding and rigor on UK dependencies. Now, one of the things that so there is a lot of atmospherics. There is some challenging big ticket items that we need to get through, which we will get through. And certainty will return, and confidence will return, and people will begin to get on and do the things that we like doing, which is getting on with our businesses or getting on with our plans. What I wanted to really share with you at a sort of helicopter view, first of all, and we might get into this in the Q&A. I haven't particularly shared this slide deck on the call today because the teams in the UK, sector by sector, have produced quite a detailed sort of information around what's on offer if you're looking to move your business, in terms of incentives, in terms of tax credits that you might get, as well as some practical advice on where's the best place to go in the UK if you're a particular business, etc., etc. And one of the things I wanted to do in my opening address is just to, first of all, say that we in the Department for International Trade have a responsibility to support businesses who do want to either expand into the UK or move to the UK or pursue a capital investment into the UK. And we will tailor what support that we are able to offer you subject to whatever it is that you want, particularly what sector you're interested in, etc. So, you know, in terms of the business environment, we think we're pretty friendly. It's, you know, there's been many decades of deregulation, which means it's a good market for you to get into. We're first in Europe in terms of trade on online retail in particular. Notwithstanding the impact of COVID, the underlying estimates of the IMF is that we will continue to grow as an economy. As I mentioned before, corporation tax is the lowest in the G20 at 19%. There had been plans actually to go lower, but they got paused as a result of COVID, so they may return to that. If you're an investor that is looking to invest in new technologies, research and development, or you've got patents that you want to again sort of register in the UK and develop from the UK, there are tax incentives that are available. In terms of innovation and sort of research, there are a plethora of different funds that you can access from Innovate UK, from research councils, depending on whether what kind of industries that particularly you're looking in. On the kind of employment and the talent scene, I mean, the UK still has an incredibly high employment rate at 76.5%. Our unemployment rate as of last week was published at 4.8%, which contrasts to Hong Kong's 6.4%. And if you put COVID to one side for a minute, the rate of unemployment, UK, Hong Kong, pretty much tracked each other, which, considering, you know, the UK is 10 times the population size and not on the doorstep of one of the biggest economies in the world, that's quite an achievement. And in terms of infrastructure, both sort of travel and digital, you know, 95% of the country has got super fast broadband, and we're sort of considered 10th in the world in terms of digital ready for businesses of that nature that want to deploy. So there's a lot of information, there's a lot of things that we can do to guide and support you in your journey. We don't try and replace what the market do. So you're going to hear from colleagues in 3CS and ELLALAN as well. You will, you know, you need the professional support. I actually was told by my team that 3CS are at the top of the list of advisories when you go on to the government's website for organizations that can assist you, which I believe is because it's in alphabetic order. So very wise naming of your business, 3CS. You got it right because you're top of the list. But where we do particularly, I think, brings, and this gets into scale, is if you're thinking, I need some financial support, or I need some introductions into different parts of the country, for example. So when I talk to Hong Kongers about investing in the UK, it's always London, London, London. Now, increasingly, well, a little bit more, we're hearing Manchester. So people are looking around those parts of the UK as well, and also a little bit more Birmingham. It's no surprise that Bank of East Asia has branches. Well, it's had branches in London for many decades, but it's opened branches in Manchester, it's opened branches in Birmingham. And when I talk to the chairman of the Bank of East Asia, he tells me, I go where my clients go. So that gives you a sense of which parts of the UK some of the folks are looking at. But we know all the key business support organizations. We know the local governments and local authorities, the mayors of those cities. In fact, they all regularly come out to Hong Kong when they are looking for partners or investors. So there's a very long relationship. And indeed, one of the biggest investors in Manchester is a Hong Kong conglomerate who have invested heavily in housing, mixed-use retail. And interestingly, what they've been telling me is they're bringing some of the Hong Kong retailers into their retail operations that they're establishing in places like Manchester. So that sort of insight that we pick up through supporting the sort of the big tycoon investors or families can sometimes be quite helpful depending on the nature of what your particular business is, because you know, it's always nice to get alongside a familiar friend from Hong Kong if you're making a first step into the UK. So in a very sort of, and I'll round up now because I've got about 20 minutes to cover on this speech. The main thing I would say is, you know, if you are active and you are serious and you want to pursue investment into the UK, by all means, you can get in touch with my team here. And I think the team at 3CS have some contact details for that. And what they will do is have initial conversations with you and share some of the more detailed material that we think is more relevant to you. So rather than give you 150 pages of stuff that you won't read, we'd rather tailor it to what we think you're interested in. And depending on the scale and nature of what you might potentially be looking to invest in, or what kind of business you might want to set up, then in certain circumstances, we can appoint a project manager in the UK who will help you with all manner of things from visas to access to authorities, et cetera, et cetera. So, so I would leave you with the thought now that yes, there are some big challenges right now. We will overcome them, and we will end up in a much clearer headspace. You know, we as a government department are there to promote and support any of you that want to make that journey. We don't charge, and we've nothing to gain or lose other than your wonderful company in the UK. So I will pause there and hand back to Key.
Thank you very much, Paul. It's a very good insight, the overview. Now on to Key's part.
Yes, good morning and good afternoon, depending on where you're joining us from. I am Keith McAllister, a director of 3CS and head of the corporate commercial team. I want to go to the next slide, please. Notwithstanding our cunning at getting to the top of the list of advisors, here's a sample of some of the companies that we act for. We're obviously very proud to do so, and some of the accolades we've received. What I'd like to do is look at what should be considered when setting up or acquiring a business in the UK. If you could move on to the next slide, please. But before doing so, I thought I would just ask the question, why invest in the UK? Well, the UK is a long-established international hub with a strong trading history. The London Stock Exchange is one of the strongest capital markets in the world. The UK scores highly on the ease of doing business with a flexible and open business environment. We have got good public services and infrastructure. And of course, English is still the common language of international trade. The UK also has a well-respected legal system both in terms of English law governing contracts and the English courts delivering fair judgments. Next slide, please. So there are a number of different types of entities that can be set up in the UK, depending on an overseas company's goals. The most common are a limited company or subsidiary, a branch, and a limited liability partnership. A limited company is a separate entity with its own independent legal identity. The company will be owned by its shareholders, and many international companies use this route to create a UK subsidiary. It will have a distinct board of directors and be able to enter into contracts in its own right. And a company gives limited liability, which serves to protect both the directors and the shareholders. A limited company will be liable for UK corporation tax on its profits. There are two principal types of limited liability companies, public and private. Given the lighter regulatory regime that applies to private companies, most wholly owned subsidiaries are incorporated in this way, unless there are special circumstances. There are a number of filing obligations on limited companies, which are maintained on the public record at Companies House, including annual accounts and details of the persons with significant control. Incorporating a company, which is feedback we get every time we act for overseas companies, is amazingly quick and straightforward. It can be done on the day. If an overseas company is carrying on business in the UK from the establishment of a fixed or permanent base, which constitutes a taxable presence or a permanent establishment, but doesn't want to set up a separate legal identity, it will be required to register the UK branch at Companies House. In legal terms, a UK branch is considered the same legal entity as the parent company. So there's therefore no independent legal personality as such, and all profits and losses of the UK branch are incorporated with those of the parent. All debts and liabilities of the UK branch will also be attributed to the parent company. Before describing limited liability partnerships, or LLPs, I just want to describe the unincorporated trading options. So it is possible to carry on business without the corporate protections of companies or LLPs. So an individual can carry on business in his or her name as a sole trader, or with others as a partnership. But in both these cases, the profits and, more importantly, the losses and all liabilities will be personal to those individuals. An LLP is an incorporated partnership. So an unincorporated partnership is obviously where they're carrying on business together in their own names, even if they have a collective trading name, whereas the LLP is that partnership, but carried on through a corporate vehicle. So the LLP has a separate legal identity like a limited company, and each partner's liability is, in general, limited to his or her agreed contribution to the partnership, just as a shareholder's liability is limited to the amount payable on their shares. LLPs are straightforward to incorporate, and they can be efficient structures for the repatriation of profits, as the profits are attributed to the members rather than the LLP itself. An LLP is not as well recognized as a limited company, and it does require at least 2 members, unlike a company which can be set up by 1 person. An LLP must also file UK tax returns on the profits which the LLP derives from UK activities, which may be burdensome. Generally in the UK, LLPs tend to be used for professional partnerships or for specific joint ventures, often property joint ventures. Next slide, please. I just want to look at some of the investment contracts. For these purposes, I'm ignoring any contracts for the acquisition of assets. I know Charles is going to touch on shareholder agreements in his talk, so I won't go into detail here. And an LLP agreement is to an LLP what a shareholders agreement is to a company. In other words, a contract between the members regulating their relationship with each other. I would like to mention articles of association. Every company in the UK must have one, and they constitute a contract between the company and its shareholders. Generally, they deal with provisions relating to meetings of the board and the shareholders, transfer of shares, conflicts of interest, delegation of authority to the board, and so on. Usually the shareholders agreement, if you have one, will provide more bespoke terms on these points, and the shareholders agreement will override the articles. However, some of the more basic provisions relating to company management will remain in the articles. And the UK government has published what are called model articles, which the vast majority of companies are incorporated with, sometimes with specified variations. The thing to remember is that the articles are a public document, so usually they are kept relatively straightforward, and the specific agreements between the shareholders are contained within the shareholders' agreement. If your investment is by way of a wholly owned subsidiary, then articles are all you need, and quite honestly, model articles is the most straightforward and cost-effective option to go for. If we could have the next slide, please. So this is just looking at some of the types of investment you can do. Share and asset acquisitions I've mentioned, but Charles is going to talk about those in his talk, and the concept is the same, whether it's UK or Hong Kong. So I'll leave that to Charles. And similarly, minority investments and how they're dealt with in shareholder agreements, I think Charles is touching upon. But obviously what you can do, and what we sometimes find with overseas companies, is that they take a smaller minority shareholding in a business, sometimes with an option to buy out the business, sometimes just to get a foothold in the UK territory. Franchises are another way in which we sometimes see foreign companies coming into the UK. Sometimes it's to bring an existing franchise that exists outside the UK. So we with various clients who've brought in franchise in the food and drink sector. And some of the franchises, even within the UK, can be territorial. So it may be you have London as your territory, or you may have England as your territory, and so on. And the surrenders can be surrendered at the end of the term, but they can also be sold at the end of the term. So not only will they provide profit on an annual basis, there can be a capital value at the end of the term. Distributorships is another area where we find foreign companies coming into the UK. There's generally little law around these, so they tend to be governed by contract between the parties. They can be exclusive, they can be non-exclusive. Sometimes you can have them where even the supplier or the manufacturer is prevented from selling into the agreed territory. But again, we often find this is a way that overseas investors come into the UK. I've mentioned agencies as well. They're probably less likely for overseas investors to do themselves. But occasionally they may come in as an agent for an overseas entity. Unlike distributorships, there's a lot more law around commercial agents, and there is provision for compensation for agents at the end of their appointment. So I just make the point that if you're going to go into an agency arrangement and you're going to appoint an agent, bear in mind that there will be a cost at the end of their term. That is derived from European legislation. So if you're coming into the UK because you want a European presence, that will be the same principle, whether the agent's in the UK, Germany, France, or wherever. That will not be affected by Brexit. If we move on to the next slide, please. I know Paul touched upon some of these things, but I just wanted to give you a brief oversight on the UK tax regime. In terms of administration, regardless of the corporate structure, the company, the LLP, or the branch must register with HMRC, which is the UK tax authorities, to pay all of the business's tax liabilities. As Paul mentioned, UK resident companies are generally liable to corporation tax at 19% of their worldwide income and gains. Non-UK resident companies are liable for the same tax on profits or gains made in the course of carrying on a trade in the UK through a permanent establishment. So in other words, the branch will be subject to the same tax rate. Sometimes we find with overseas investors, they purchase companies whose only asset is a residential property, And the corporation tax on that will be 28% on profits made on the sale of the residential property, which reflects individuals' tax on the same. So there's no corporation tax protection by putting a high value property within a corporate vehicle. Companies are required to calculate their own corporation tax liability, and they have to file their tax return with HMRC on a self-assessment basis. And similar returns are required for non-UK resident companies disposing of UK property. Value-added tax is a form of consumption tax or an indirect tax, and it's charged on the provision of most goods and services in the UK. A UK company or the branch of a non-resident UK company must register when turnover exceeds £85,000 per annum. So again, if you're coming in as a startup, you may not need to register initially, but you need to remember that if you hit 85,000, you need to be registered for VAT. And then you generally need to charge VAT to customers, although supplies to non-UK customers may not be subject to that. And there are certain rates that are, the headline rate is 20%, but there are some reduced rates for certain goods and supplies. Income tax is deducted from an employee's salary on a monthly basis through a system known as pay as you earn. And most employees in the UK are eligible for a personal allowance on tax-free income. And then there are varying levels of additional tax bands, with the highest in the UK currently being 45% for taxable income above £150,000 per annum. National insurance is the UK's version of social security. So employees and employers make a contribution to qualify for certain benefits and for the state pension. It relates to a percentage of the gross salary or wages that's paid to the employee. It's currently 14% for employees and 13.8% for employers. Paul mentioned tax incentives. Again, I'd just like to reinforce that in terms of inward investment. There are a number of tax incentives that can be used to offset corporation tax liabilities, including research and development expenditure and what's called patent box, which is a lower rate of profits which have been derived from patented or certain other innovations. Next slide, please. I just want to have a quick look at intellectual property rights. The UK consistently ranks highly in global intellectual property indices for offering businesses a well-developed regime for the protection and monetization of intellectual property rights. Many aspects of the UK intellectual property rights will be familiar for businesses operating internationally. Trademarks, trademark registration offers monopoly protection for brand names, for logos, for other signs indicating trade origin. So provided the mark sought is not identical or confusingly similar to another existing mark, then the registered mark may be obtained relatively inexpensively for an initial 10-year term, which can be subsequently renewed for further 10-year terms. The law of passing off prevents others from benefiting from an established trader's goodwill and causing damage by misrepresenting their goods or services as those of the established trader. Key brands and logos should be protected as registered trademarks, since they can be enforced without needing to prove goodwill and misrepresentation, which is necessary in relation to passing off. Copyright relates to an author's original intellectual creation from being copied by others. So it'll be literary works, graphical designs, photographs, artistic musical works, and so on. The term of copyright protection is generally 70 years from the last year of the author's life. Certain sorts of copyright have slightly more limited durations. Computer-generated works, for example, is limited to 50 years. And first ownership of copyright vests in the author upon the creation of the work. So if the work is created by an employee in the course of their duties, the copyright vests automatically in the employer. However, if copyright works are commissioned from non-employees, such as an independent contractor or a design agency, or it's created by an employee but outside their normal duties, then the copyright will stay with that employee or that design agency. And whilst the commissioning party will have an implied license to use the copyright, It may not necessarily be exclusive. And it's therefore necessary, if you're commissioning somebody to create that copyright, or to put, or an employee where they're doing things on company time but not in their normal company duties, to ensure that by way of contract, that the copyright in the commissioned work passes to the commissioner. And then just briefly, patents, they protect new inventions that are capable of industrial application. So they give a monopoly right to work the invention, if you like. So in other words, to use the patented process or make the patented product. And they're generally available for a period of 20 years from the original filing date. Next slide, please. I just wanted to touch briefly on sort of trading and regulation. So some industries in the UK are heavily regulated, including notably the financial services sector. So when establishing a business in the UK, it's important to ensure that the company has obtained all the requisite licenses to trade. So in the UK, the Financial Conduct Authority, the FCA, is the competent authority for regulating financial services, and all what's called regulated activity carried out in the UK needs to be done by someone who is FCA authorised, or it's otherwise exempt. So in other words, any form of dealing in investments, arranging investments, taking deposits, giving investment advice, fund management, these are all regulated activities, and they have to be done by an authorised person. Trading contracts, obviously if you're going to trade in the UK, you're going to have contracts. There's a number of things to bear in mind, that we've got legislation in relation to unfair contract terms. We've got legislation in relation to unfair commercial practices. We've got legislation on product liability. And there's also rules in what you can and cannot limit your liability for. So you cannot limit your liability for death or personal injury caused by negligence. Just a little bit tight on time, so I'll just mention sort of very briefly, we've also got legislation relating to bribery, and that extends to behaviour outside the UK. And we've also got legislation in relation to modern slavery, and that also applies to supply chains. Next slide, please. And finally, Brexit is the elephant in the room, and we are close to knowing whether there's a deal with the EU or not. I suspect, I remain optimistic like Paul, that we will have a deal, but I think if we do reach a deal, it may not be fully comprehensive. So there may be scope for further side deals to be done in the months and years ahead. But I think the thing to remember is, whether we get a deal or not, the UK has left the EU customs union, and it has left the single market with its 4 freedoms of movement of goods, services, people and capital. And that does bring consequences. So UK businesses moving goods in and out of the EU will now be importers and exporters. So there's various administrative consequences, such as getting a registration number, filling out customs declarations, and various responsibilities, such as ensuring that in relation to goods, that if they require a conformity assessment, it's done and the labelling is correct. The UK has also benefited from EU rules of origin. In other words, where a finished goods must contain a sufficient percentage of materials and processes within the EU to make them deemed to be from the EU. Obviously, that will change post-Brexit. So the materials and the processes have to be from, the percentage will have to be from the UK to satisfy rules of origin in whatever free trade agreements the UK has with other countries. And then related to this is the effect on supply chains, where goods are transferring across the EU and the UK border. The UK has also set a global tariff for trading with countries which it doesn't have a free trade agreement with. And I think the general consensus is that this has simplified the existing tariff situation with countries that we don't already have free trade agreements with. So to summarise, I think the UK remains a great place to invest and do business. There are various ways to structure the investment, which we'd be delighted to help with. There are trading obligations that require ongoing compliance, which again, we'd be delighted to help you with. Brexit will have an effect, but it is difficult to predict what that will be. However, if we look at some of the free trade agreements that have been signed already, it's clearly the intention of the government and those third-party countries to try and keep closely aligned to existing arrangements, at least in the short to medium term. So I would hope that this is going to result in business as usual to a large degree, and it will maintain the UK's position as a popular and significant place to invest. Thank you.
Thank you, Paul. Sorry, thank you, Keith. So on to the next part, which is my part. I'm Keith Lee, Associate Solicitor of 3CS in the Real Estate Department. So in this topic, legal considerations of investing in the UK real estate market, I will be briefly covering these areas. Next slide, please. Types of legal interest ownership in the UK, residential property, commercial property, basics of development, main terms of a commercial lease from a tenant perspective, real estate finance, and property taxation. Next slide. Types of legal interest. There are broadly two types of legal interest in the UK. Scotland and Northern Ireland have very similar but slightly different concepts. For the purposes of this webinar, the terminology used are applicable to England and Wales. So the two types of legal interest are freehold and leasehold. A freehold is an interest in land which is owned outright with no time limit on ownership. Because of the absolute ownership nature of freehold, the owner generally has more control over the land and can use the land however they wish, subject to planning and any third-party rights. An interest of leasehold interest in land provides the owner with an exclusive use of the property, but not ownership. The interest is created by a document called a lease, which is granted by a freeholder for a fixed term in exchange for a specified payment of rent. At the end of the term, the lease comes to an end and the property reverts to the freeholder. Next slide. So residential property. These are the most common types of residential property in the UK. So you have single dwelling house, which is a self-contained property with no shared areas, such as a house, apartment, a self-contained flat with shared access areas, house in multiple occupation. This is a property, typically a house with more than two unconnected tenants sharing the common facilities such as bathroom and kitchen. Purpose-built apartment block. This is a building containing a number of flats. It can be a small building such as a house converted into 4 apartments or a large building with over 100 apartments. The legal requirements are different depending on the type of property. For example, an HMO, we will look at whether the property has the required planning permission and if the requisite HMO license is in place. Tenancy. Most residential properties are rented out using a document called AST, which is short for assured short-hold tenancy. This is a short-term letting arrangement whereby the duration and rent are fixed and is the most widely accepted form of letting arrangement for both the landlord and tenant. There are several legal requirements which need to be considered when renting out a residential property in the UK. Health and safety documents. These are the gas safety certificate, which needs to be provided on an annual basis, electrical installation report certificate, which needs to be provided at least every 5 years. Failure to do so could adversely affect the landlord's ability to take back the property. Energy performance certificate. This confirms the energy efficiency of the property, which by law must be no less than an E rating. If a landlord rents out a substandard property, they could be fined for non-compliance. Tenancy deposit scheme. Deposits from tenants must be protected under one of the deposit schemes. Failure to do so could adversely affect the landlord's ability to take back the property, and the tenant could be entitled to compensation. The Tenant Fees Act 2019 banned certain fees that landlords and letting agents have historically charged tenants, such as reference fees and inventory check fees. Landlords in breach of this act can be fined up to £5,000 for first offence and up to £30,000 for repeat offence. Next slide, please. Commercial property. So these are the most common types of commercial property in the UK. There's retail premises such as shop and department stores, offices. These can be a floor in a building or a whole building containing offices. Mixed-use buildings, as the name suggests, these are buildings with more than one use. For example, retail on the ground floor and offices on the upper floors, or a combination of offices and residential apartments. Hotels, warehouses, such as properties used for storage and distribution, and industrial units such as factories. As with residential property, different types of commercial property require different legal consideration. There are different types of letting arrangements when it comes to commercial property. Lease is the most common. It is a grant of a right to the exclusive possession of property for a determinable period of time. A license to occupy is a personal right given to the occupier to do something in the property and does not provide exclusive possession. An example is surfaced offices. Tenancy at will is similar to a license, but either party can terminate at any time. This is not as a common agreement and is often used as a temporary occupational arrangement only. It is important not only to use the right type of agreement, but also to ensure the contents of the agreement reflect the intention of the parties, as we will see in the section on lease later. Security of tenure. This is a powerful protection given to business tenants under the Landlord and Tenant Act 1954. The protection is twofold. First, a business tenancy will not come to an end at the expiration of a fixed term. Secondly, on expiry of a business tenancy, the tenant has the right to apply for a new tenancy on similar terms. The importance of this when buying a commercial property subject to a protected tenancy is that it could be difficult and costly to terminate such a tenancy. So other considerations when acquiring a commercial property. Planning. When we talk about planning, we really are looking at whether the property has the required permitted use and whether a development has taken place at some point in the past. The term development in property law is used to cover a wide range of activities and not limited to large-scale development, which is what most people think of when referring to development. So, for example, a change of use can constitute a development, and so can certain minor building works. The last thing you want is to acquire a property for investment only to find out that it does not have the required permitted use or there is a breach of planning law. Development law in itself is a substantial area of law, as we will see later. Environmental issues. This is another specialist branch of property law and is to do with contaminated and polluted land, whether it's naturally occurring or man-made pollutants. It is usually more relevant when acquiring warehouses and industrial properties or properties built on former industrial sites. The presence of contamination in land can have very serious consequences. It can make the property difficult to sell or impossible to use for certain purposes. The Environmental Protection Act 1990 imposes a liability on the person who caused the contamination. These people are categorized as Class A persons. However, innocent owners and occupiers are categorized as Class B persons and can be held liable if the Class A person cannot be found. This is why it is important to carry out a survey when acquiring a property. And remediation. Cleanup cost of contaminants is usually very expensive. It can turn what would otherwise be a profitable development into a loss-making one. Next slide, please. As mentioned earlier, development covers a wide range of activities. Most people think of investing in development is building something from the ground up. In recent years, real estate investors have been more creative in maximizing profit. For example, there has been an increase of certain types of developments, such as converting offices into residential flats, conversion of houses into HMOs, and Also, we've seen in the last several years, live work space, where the tenant lives and works in the same property. Whether you are acquiring property to develop, entering into a joint venture, or buying a newly developed property, there are certain legal considerations. Restrictive covenant, this is a restriction limiting the use of land or restricting the owner not to do certain activities. It runs with the land, which means it continues even with the purchaser when the purchaser sells the property to another person. Generally, development on freehold land is preferred because of more control and less restriction, as mentioned earlier. Leasehold land can still be developed, provided any covenants and restrictions do not conflict with the development. Planning is when architects are instructed to draw up plans and to apply to the local planning authority. It is now common to see properties on the market with the benefit of planning permission, which is essentially selling the development's potential. It is essential that existing planning permissions are carefully checked to ensure it reflects the development being sold. Conditions. Nearly all planning permissions are subject to conditions. Some must be satisfied before commencement of development, some during the development, and some before occupation of the completed development. It is important to check these for two reasons: that there are no onerous or unreasonable conditions attached to the planning permission, and that there is no breach of any condition. The local planning authority can take enforcement action for a breach of planning condition, which can include stopping the development, compensation, and reinstatement. Section 106 agreement. This is an agreement between the developer and the local planning authority to address issues arising from the development, such as impact on road traffic, public transport, capacity, and so on. This usually involves a financial contribution to the local authority. Again, this needs to be checked to ensure there are no outstanding obligations, otherwise the local planning authority can take enforcement actions. Next slide, please. Commercial lease. So far, I've been covering considerations which are relevant to acquiring properties as an investment. When a business sets up or expands its business, occupational premises are most likely relevant, be it a retail shop, an office, or a warehouse. As a tenant entering into a commercial lease, the terms of the lease are the most important. I list out here some of the main terms that need to be considered. Length of term. Traditionally, leases are granted for a term of 15 or 20 plus years. However, in the last decade, we have seen the average length of leases reduced significantly. This is due to change in the market and business needs. Use. This is separate to permitted use under the planning law, as briefly covered earlier. As a commercial lease is a contract between the landlord and tenant, the parties are free to negotiate the user clause subject to the permitted use. For example, a property can have office use as a permitted use, but the landlord can restrict this further by only allowing office use for financial services. Rent. Tenant needs to consider if the rent is the market rent for the property and if VAT is payable on the rent. Rent review. It has long been a standard practice to have an upward-only rent review at fixed dates. How and when the rent should be reviewed can be an area of contention between the landlord and tenant. The rent review clause should be fair and acceptable to both parties. Break option. This is an ability to terminate the lease early. Traditionally, break options are at fixed dates and usually after 5 or 10 years of the term. In a current rapidly evolving market, it is difficult to predict what would happen in 3 years' time, never mind in 10 or 15 years' time. Therefore, in recent years, break option is becoming more common, but at more frequent dates during the lease term. Alienation. This is a term which means disposing of the lease, such as selling or underletting. The ability to sell or underlet the lease is an alternative to terminating the lease early and is another way of adding flexibility to a lease. Repair. Responsibility for repair depends on whether the lease is of the whole or of part of a building. Where the lease is of the whole building, it is normal for the tenant to be responsible for the repair of the whole, both internally and externally. For a lease of part only of the building, it is normal for the tenant to be responsible for internal repairs and the landlord to be responsible for external repairs, common areas and services. So these are just some of the main terms which require careful consideration before entering into a lease agreement in order to protect the parties' current and future position as much as possible. Next slide, please. Real estate finance. Very few real estate investments are funded without finance. This is the case even for cash-rich investors. The use of finance can extend the reach of investment and therefore maximize profit. I've listed here the three most common types of real estate finance. So buy-to-let, as the name suggests, buying a property to let out. The rental income will be used to service the loan from the lender, and this type of finance is usually only available for residential properties. Development loan is financed to fund the development of a property and can include acquisition of the pre-developed property itself. These are specialist loans and should be handled by lawyers with requisite development finance experience. Bridging loan. This is a short-term finance and is normally used for the acquisition of properties. These types of loans usually have higher interest charge, but are readily available and therefore suitable where the property acquisition has to be completed in a very short space of time. Because of the short-term high interest nature of bridging loans, it is important to have an exit strategy in place. For example, refinancing using a mainstream loan from a bank when the bridging loan expires. Security requirements. These are requirements of the lender. Before any loan is released by the lender, the security requirements must be satisfied. These are essentially the lender's high-level due diligence on the property and are dealt with by both lender and borrower's solicitors. Next slide, please. And then property taxation. There are 4 property-related taxes in this country. Stamp duty land tax, which we are all familiar with. It is a form of acquisition tax, so it is payable not only on the purchase of properties, but also on taking a new lease, as a new lease is an acquisition of leasehold interest. Residential and commercial properties are taxed at different rates. For residential properties, there is an additional 3% surcharge applied if the purchaser owns another property, or if the purchaser is a corporate body. Further, if the property price paid by the corporate is over £500,000, the SDLT is charged at 15%. These are measures introduced by the Finance Act 2013 designed to contain rising house prices. And then you have annual tax on envelope dwellings. This is a form of holding tax and was introduced by the Finance Act 2013. This applies to residential properties with value of over £500,000. It is charged and payable annually according to the band that the property falls under. For example, for a £500,000 property, the annual charge is £3,700 for the tax year 1st of April 2020 to 31st March 2021. Relief from the 15% SDLT and ATED is available for property investment companies, i.e. companies whose business is in properties such as developers and landlords. This is one of the reasons why special purchase vehicles are used to invest in properties in the UK. Value added tax. Most properties, residential or commercial, are exempt from VAT or are zero rated. However, the owner of exempt properties can opt to tax, which has the effect of removing the exempt status, making the property standard rated. This is very common practice, especially for commercial properties for tax reasons. Relief is available on the purchase if the transaction qualifies for TOGC, which stands for Transfer of Business as a Going Concern. This is when the buyer will be carrying on the same business in the property as the seller. And then finally, capital gains tax, corporation tax. In the context of property, this is a form of disposition tax and is payable by the individual or body corporate on the gains made from selling a property. It is important to note that the rules changed in the last couple of years, which meant that non-UK residents and corporations are liable to pay CGT or corporation tax on gains made from selling UK properties. And that's the end of legal considerations of investing in the UK real estate market. And now I will hand over to Charles. Thank you.
Thank you very much. So this brings you to the last session, and good afternoon and good evening, depending on where you are, or good morning. So I'm a Hong Kong lawyer, specializing in intellectual property and technology, heading up the corporate commercial department of the firm. So previously I've worked in-house for Tencent and for Fox. So I'm quite specialized in technology and media. Next slide, please. So yeah, this is just a brief introduction of our firm, where we got numerous awards for intellectual property, and Keith actually covered quite a lot on IP today, which was great. Next. So today I'm going to cover quite a wide range of topics. I thought it would be more useful to touch upon lightly on each topic rather than delve into them in too much detail. And for certain topics, I'll skip over them quite quickly, as it has been covered previously by Keith. Next slide. Yep, so you can see various topics. And so, as Keith has mentioned, there are various company structure that could be used. And you would note it's quite interesting. I'm talking about it from a Hong Kong law perspective, but basically it applies in the UK as well, because Hong Kong and UK are both common law jurisdiction, and many years ago Hong Kong's laws actually has been developed based on UK's laws. So as Keith has mentioned, next slide. The most common type of vehicle used would be a limited liability company, as it gives you a separate legal entity. So if anything happens in terms of liability, you're personally not liable, and your loss would be limited to your investment in the limited company. Next slide. So I'll talk a bit more on shareholders agreement. I advise a lot on startups and MNCs. Basically, I would say if you're holding company shares in a private company, or you should always have a shareholders agreement, even if it's two brothers or even between spouses, because we've seen many cases where there would be disputes between shareholders, especially not just when the company does not do well. Actually, most of the disputes arise when the company, the investment does really well, because a 1% difference in a billion-dollar company is a significant stake. And we've done litigation involving brothers, co-founders of companies who at the beginning were buddy-buddy, great friends, but when the value of the shares become huge, then they enter into disputes. So what is a shareholders agreement? I mean, in short, it's an agreement that governs the relationship between shareholders. And most commonly, you would have clauses talking about when you could transfer your shares and when you could exit and when you could, and if there are a dispute between shareholders, what is the mechanism for resolving it? Without these provisions in an agreement, the law actually has very limited protection for minority shareholders or for disputes. Basically, it says, well, two parties have, or three parties have entered into becoming shareholders of the company. And as long as nothing illegal is done, it's very difficult for you to have an option to exit without such an agreement. So next page. So some of the important clauses that I would say is restriction or share transfer. Because when you start up a company with other investors, most likely you would know who the other shareholders are. And you've become shareholders in the company because you want to work with these people. You don't want your partners to suddenly just transfer part of their shares to someone you don't know, and then you're stuck with this new shareholder. So right of first offer. It's basically if a shareholder wants to sell their shares or transfer their shares to a third party, they have to offer to transfer or sell those shares to you first before they could offer it to a third party. A lockup provision is you would want to lock up, let's say a few friends are getting together or business partners are getting together to we're going to do this partnership investment for 3 years. And so you want to have a lock-in saying, well, for the first 3 years, you're not allowed to transfer your shares to third parties. And drag along rights, it's when a majority shareholder or a group of shareholders who together are the majority offer to, let's say a shareholder owns 90% of the shares and they want to sell it to a MNC, but the MNC says, well, I want to buy the whole company. I don't just want to buy 90% of it. So if you have a drag along right, as the majority shareholder, you have the power to drag along basically the minority shareholders, saying that, well, if let's say over 80% of the shareholders agree to sell, then the remaining shareholders have to sell at the same terms. So that's a drag along, and it's in favor of the majority. And similarly, there's a tag along right where minority shareholders could say, well, if majority of the shareholders are selling out, I want to sell out as well. I don't want to be stuck with this MNC where I hold 10%. So if there's a tag along right, the minority shareholder could basically say, well, if over 70% of the shareholders decide to sell, then the new buyer has, if I want to, the new buyer must buy my shares as well. If the new buyer does not agree to buy my shares, then they can't buy your shares either. So that's a tag along right. And liquidation preference. So this is usually what investors would ask to have in the shareholders agreement. It's saying, well, if the company liquidates, then as an investor, I get to recoup all the monies I've invested first at a minimum before the founders or the previous shareholders are allowed to share in any of the assets of the company. And most often, actually, investors wouldn't just ask for a return, getting back what they've invested, but they would ask for like a 10%, 20% annualized return. And they must get that return before the other shareholders are allowed dip in the assets of the company. And similarly, non-compete covenants, founders would want to have a provision where the new investors are not allowed to compete with the company, basically, because they would have access to a lot of confidential information of this company. And I don't want to, as a founder, I wouldn't want to provide all this information and then have the investors basically use that information to start another company or invest in another competitor. So there would be a non-compete. And similarly, there would be a non-compete required by investors on the founders, basically saying if the founders exit the company, you're not allowed to go then in the next 5 years, start up a similar company that competes against the business. And reserve matters, these are very important for minority shareholders. Essentially, it's saying, but let's say without reserve matters provisions, any matters that need to be decided by the company would be decided on a vote count, and that would be based on the number of shares that you have. So as a minority investor, if you just voted based on your shares, your votes don't really change anything. So what investors would typically ask for, it's a list of reserve matters where it's listed out that if these matters have to be decided or have to be done by the company, then the majority of investors, basically shareholders excluding the original founders, have to vote, and the majority have to agree before these things could be done. So this would allow investors to have more control over certain aspects of the company. Things that would be typically covered in the reserve matters would be taking out a huge loan, starting a new subsidiary, or branching out into a new country. Basically significant things which is more than a day-to-day operation. Next slide, please. So non-disclosure agreement. This is something that I think if you're planning to do an investment, the company would like to ask you to sign. And similarly, if you're going to disclose information to the potential partners, basically, you should sign an NDA, because this would protect and ensure that any information you disclose during the initial discussions can't be used for any purposes. Next slide. So IP protection. Keith mentioned this as well. So IP protection in Hong Kong and UK and basically most countries in the world are similar. And I would say if you're investing in the UK and intellectual property was something of importance, then conduct an IP search in the UK to ensure that the party actually have these rights. In like basic searches like the trademark search. If they're saying they own a certain trademark in the UK, then do a search. You could do it yourself or engage a lawyer to do it. And similarly, if after you start the business, to protect the company's IP, you should register the trademark. Copyright, you don't need to register it per se, because copyright exists upon creation. Next slide. So there are different types of M&A, as Keith mentioned as well. So this common type of M&A is a share acquisition, where you're purchasing the shares of a company either by buying out an existing shareholder or by allotment of new shares from the company. And there would be stamp duty payable on such share transfer. In Hong Kong, it's 0.2%, so 0.1% by the buyer and 0.1% by the seller. Next slide. Alternatively, if you don't want to buy the whole company, there could be reasons. Maybe you don't, you're not interested in the whole company, but only a specific type of asset or a part of the business. Then you could purchase only the asset by cherry picking and only transfer those assets. Obviously, in terms of the transfer, there'll be more paperwork because you're transferring each underlying asset instead of just the whole company. And you need to ensure that it doesn't breach any of the existing shareholders agreement, which prevents that. For example, if there are reserve matters power in the shareholders agreement. Next slide. I'm speeding through a bit faster because of time. Alternatively, you could have two companies merge, but this is a more sophisticated method, which I won't talk in too much detail. Next slide, please. So it's important when you're doing an investment to always conduct your due diligence, because what you're told by the investee company is always the brighter side, and they might not be disclosing all their liabilities or financials. So you should conduct legal due diligence, financial due diligence, and just business due diligence. Next slide. So I would say, in addition to what I've mentioned in terms of really hard paperwork, in terms of due diligence, it's also important to interview the business, the management team, and the co-founders of the company to see that there's a good personality fit, and just speak with them. Sometimes if everything turns out too rosy, and the investee company just says, I'll give you everything you want, just hand over the money, you should actually be extra careful, because there is the possibility that they just take your check and literally disappear. So in addition to like professional due diligence, exercise a sanity check on whether things make sense. If things look too good to be true, there really is a chance that it is too good to be true. Next. So taxation, I think if you're investing in the UK, then obviously seek out 3CS advice on tax. I would, on this point, just mention that if you're investing from Hong Kong is a jurisdiction-based taxation system, so it doesn't apply any global taxation. Next slide. Employment, this is always an issue, making sure that the company's due diligence also covers employment issues that you may have. Next slide. And data protection, I think this is extremely important, especially when you're investing in the UK. For those not in the know, UK and the European Union has a data protection act called the GDPR, which has global jurisdiction, and a breach by a company of the GDPR makes the company liable to a fine of 4% of the group's global annual revenue. So it's important that if you're running a business or looking into investing, that you ensure that the company has satisfied with its obligations in regarding data protection. Next slide. I think that brings me to the end of the presentation and right within my time.